Welcome to the Bond Dickinson Employment Law Podcast for June 2013. I'm Karen Plumley-Jones and I'm one of the practice development lawyers for the Bond Dickinson Employment Team. In this podcast, I'm going to tell you about some of the major cases that have been reported recently, dealing with matters such as the employment status of a Methodist minister, post-employment victimisation, collective redundancy consultation, and compulsory retirement. Then I'll update you on the 25th of June employment law changes. Lastly, I'll look at some employment law news stories and give you some action points to consider. You can pause this podcast and print a copy of the slides so that you can take notes if you wish. This podcast qualifies for CPD points and counts as non-accredited training, which means that you can claim for the amount of time you spend listening to it. I'm going to start my review of major recent cases by looking at a case in the Supreme Court called President of the Methodist Conference and Preston. In this case, the court had to rule on the employment status of a Methodist minister. In 2003, Miss Preston was admitted and ordained into the Methodist Church, and in 2009 she brought a claim for unfair dismissal. Her claim was dismissed by the Employment Tribunal because it found that she was not an employee, but this decision was reversed by the EAT in a decision that was upheld by the Court of Appeal. The Methodist Church appealed to the Supreme Court. The majority view of the Supreme Court was that there was no employment relationship. Lord Sumption delivered the leading judgment, in which he explained that the Supreme Court had reviewed the Constitution and standing orders of the Methodist Church, and found that neither admission to nor ordination into the Methodist Church were themselves contracts. The Supreme Court also took into account the fact that ministers do not retire from their position as a minister. Joining the Church was a lifelong commitment, and ministers devoted their whole lives, and not just their working lives, to the Church. Ministers might leave active service, but the standing orders of the Church required that they continued to exercise their ministry as they were able to. Their ministry was therefore a vocation and not employment, and it was not governed by any contract of employment. When considering the employment status of ministers, tribunals will have to analyse the particular facts, as these are likely to vary from church to church and from religion to religion. This judgment therefore leaves a number of issues unresolved, and so we expect that this matter will be revisited. In my second case, ONU and Akwiwu and another, the EAT disagreed with the views it had previously expressed in Rostock and Jessamy, which I covered in my March 2013 podcast, and decided that the Equality Act is wide enough to cover post-employment victimisation claims. Mrs. ONU, who was a Nigerian citizen, obtained a migrant workers visa so that she could continue to work as a domestic servant for her Nigerian employer in the UK, as she had done previously in Lagos. However, following abusive behaviour and exploitation, she left her job and brought a number of tribunal claims including unfair dismissal, race discrimination, harassment on grounds of race, and failure to pay the national minimum wage. 6 months after bringing the claim, Mr. Akwiwu, Mrs. Onu's former employer, telephoned her sister in Nigeria to make a number of threats and attempt to get her to convince Mrs. Onu to drop her claims. Despite these threats, Mrs. Onu continued with her case and brought an additional claim of victimisation. The tribunal felt unable to depart from the EAT's previous decision in Rostock and found that the threats made in the telephone call could not amount to victimisation, as Mrs. Onu was no longer employed. The EAT overturned this decision. The question as to whether the victimisation claim could proceed, even though Mrs. Onu's employment relationship had ended, involved difficult questions of statutory interpretation, which the EAT held should be tackled in 2 stages. First, the tribunal should consider the Equality Act in an attempt to establish its true meaning and whether or not it was intended that employees should be able to claim for post-employment victimisation. Secondly, if that interpretation would not accord with EU law, then it must consider whether it was possible to interpret the Act as covering such victimisation. In answering the first question, although the EAT admitted that the proper force of the Equality Act was not entirely easy to discern, since it neither expressly included nor excluded victimisation claims, it found that it should not be interpreted as preventing post-employment victimisation claims, since it was neither Parliament's nor the legislation's intention to do so. When turning to the second question, the EAT found that even if the Equality Act did not provide a remedy for such cases, they would follow the grain of legislation and its general ambiguity to ensure that the Act provided adequate protection for cases such as Mrs. Onu's. It's highly unusual for the EAT to decide that it was wrong, particularly in a case that it decided very recently. However, Mr. Akwiwu has been granted leave to appeal, and the Court of Appeal is scheduled to hear Mr. Jessamy's appeal sometime between July 2013 and January 2014. It's therefore possible that the law will be further clarified in this area, and employers are advised to watch this space. Are members of a pre-existing joint consultative committee appropriate representatives for the purposes of collective redundancy consultation? This was one of the questions before the EAT in Kelly and Another and Hesley Group Limited. The EAT decided that the tribunal had failed to consider whether the representatives had authority from the affected employees to be consulted about the proposed redundancies. It didn't consider the purposes of the JCC. It didn't take into account the fact that some members were co-opted rather than elected, and it stated that it wasn't relevant that the JCC was expressly non-negotiating. The EAT remitted the case to the tribunal for further consideration. Employers often wish to consult with an existing body such as the JCC instead of going through the complicated and time-consuming process of holding an election to elect employee representatives. This case highlights some of the potential problems in doing so. My last case this month is Selden and Clarkson, Wright and Jakes, which looked at the justification of a compulsory retirement age. Leslie Selden, a former partner in a law firm called Clarkson, Wright and Jakes, brought a tribunal claim alleging that his compulsory retirement at 65 amounted to unlawful age discrimination. An employment tribunal held that the provision in the firm's partnership deed that required partners to retire at 65 could be justified. Since then, the case has been all the way up to the Supreme Court and back to the tribunal, as Mr. Selden sought to show that his compulsory retirement was unlawful, and the firm attempted to establish that its stated reasons for maintaining a compulsory retirement age, retention and workforce planning, were potentially justifiable as legitimate aims. The main argument put forward on Mr. Selden's behalf was that the firm could have employed other, less discriminatory ways of achieving its aims. For example, it was argued that a higher retirement age of 68 or 70 would have achieved the same result, with a lesser impact on the individual. A number of counter-arguments were put forward, involving detailed analysis of the judgments of the previous courts and the fact that the default retirement age was previously set at 65 and was in force at the time of Mr. Selden's retirement. It was also relevant that the partners had agreed in the partnership deed that 65 was an appropriate age for retirement. The tribunal had to find a balance between a higher retirement age, which was clearly in the interests of partners, and a lower retirement age, which was in the interests of more junior solicitors. In short, the tribunal said, the age has to reflect the expectations of the partners and associates, ensure succession, and fulfil the needs of the partnership. On that basis, the tribunal found that the retirement age of 65 was justified in all the circumstances. However, this decision may not be very helpful for employers, because the tribunal made the point that, at the time of Mr. Selden's compulsory retirement, the default retirement age of 65 was in force in the UK. This is not now the case, so this argument is no longer available. The legitimate aims identified here will not apply in all workplace situations, but there will be some workplaces where a retirement age is more easily justified, for example, those involving more physical work, or where evidence can be produced to show a decline in productivity after a certain age. Next, I'm going to go through the 25th of June employment law changes which are being made under the Enterprise and Regulatory Reform Act. The qualifying period for unfair dismissal won't apply where the main reason for dismissal is the employee's political opinions or affiliation. The dismissal won't be automatically unfair, and the usual rules on unfair dismissal will apply. The whistleblowing changes are probably the biggest change. An employee will have to reasonably believe that a disclosure is in the public interest in order for it to be protected. It won't have to be made in good faith, but compensation can be reduced by up to 25% if it's made in bad faith, and an employer will be vicariously liable for victimisation of a whistleblower by a colleague. The government will have the power to legislate to make caste discrimination unlawful, but this probably won't happen for a year or two. There are also some changes in the tribunal. EAT judges will hear cases sitting alone unless they direct otherwise. Annual adjustments to tribunal awards and redundancy payments will be rounded up to the nearest pound instead of £10, and the increase in the amounts will take effect on the 6th of April every year rather than the 1st of February. Lastly, a tribunal will be able to make a deposit order in respect of a part of a claim or a response, and it will also be able to make a preparation time order and witness expense order to a litigant in person. And now some employment law news items. Following a public consultation, Acas has published a revised draft code of conduct on settlement agreements. From this summer, offers or discussions about settlement agreements won't be admissible in ordinary unfair dismissal claims provided that certain criteria are met. The revised code of conduct contains a number of important differences from the first draft, including allowing employees to be accompanied by a colleague or trade union representative to settlement agreement discussions, making it a requirement that employees must have a minimum of 10 calendar days to consider any offer, allowing for initial offers to be made orally, although any final agreement must be in writing, and moving the template letters from the code to non-statutory guidance. The new employee shareholder status is expected to come into effect on the 1st of September this year. The government has made amendments to the Finance Bill 2013 that will mean that advice on employee shareholder status will not be subject to income tax. The concession is limited to tax advice comprising only of an explanation of the tax implications of employee shareholder agreements generally, and advice about the terms and effect of the employee shareholder agreement. On the 29th of May, the law on disclosure of cautions and convictions was relaxed with the coming into force of new filters on criminal records checks. From now on, certain protected convictions and cautions, that is, older or less serious ones, won't need to be disclosed other than in relation to a small number of positions involving the police and national security. Since the 17th of June, individuals have been able to subscribe to an update service that keeps their criminal record certificate up to date and allows them to take it with them when moving between jobs with similar checking requirements. Employers are able to carry out free online checks to find out whether there have been any changes to an individual's certificate. There are several action points that you should think about as a result of the developments I've covered in this podcast. Ensure you avoid victimising employees after their employment ends. The most common example is in relation to references, so you should make it clear who has authority to give references. If you're carrying out collective consultation in connection with redundancies or a TUPE transfer, and you're consulting with a standing body, check that it has authority to consult on behalf of the employees in order to avoid claims for a protective award. Where you have a compulsory retirement age, keep it under review and ensure that it remains a proportionate means of achieving legitimate aims. And update your whistleblowing policy if you haven't already done so. I hope you found this podcast useful. Please get in touch with your usual Bond Dickinson contact if you have any queries. I'll be back next month when I'll be taking a look at the new employment tribunal procedures and fees regime. Thank you for listening.